God, hindi ko pala siya na-record. Okay. Mr. Itulye, nasa si Mr. Itulye? Can you explain ano yung Statute of Limitations? Sa imo lang nasabtan ha?
Period of assessment, ma'am.
Period of?
Assessment.
Okay, so yung Statute of Limitations for assessment, yan yung period within which the BIR is allowed to assess a particular taxpayer. Okay? So, syempre, nalambayan na siya period of time, no? Diba? Nalaman na siya kanang period of time niya after which dili na ka pwede mag-assess, no? Dili na maka-assess ang BIR. So since na ngayon kag-extension of time for the payment of the estate tax, then therefore dapat naapoy benefit on the part of the BIR, di ba? The government. So i-extend po nila or i-suspend po nila ang Statute of Limitations, no, for the assessment of estate tax. Okay, kindly read, no, the rest of the provisions. Payment by installment, yes, pwede ka maka-request, no? If the estate has insufficient cash, no, to pay the total estate tax due, you can ask for installment, no, payment within 2 years from the statutory date for its payment without penalty and interest. Okay? Kung for example, dili ka mangayog extension of time to pay taxes, you can ask for installment payment. Okay, pwede. 2 years, within 2 years. So, another point here is who is liable for payment of estate tax. Okay? It shall be paid by the executor or administrator before delivery to any beneficiary of his distributed share of the estate. So before nimo i-deliver ang share sa mga heirs, you should pay first the estate tax. That is the duty of the executor or the administrator as the case may be. Okay, they are primarily liable to the estate tax, the executor or the administrator. Subsidiarily liable are the beneficiary. Okay. Section 92, discharge of executor or administrator from personal liability. So, if the executor or administrator makes a written application, mag-apply lang siya sa commissioner for determination of the amount of the estate tax and discharge from personal liability. Therefore, the commissioner, as soon as possible and in any event within 1 year after the making of such application, or if the application is made before but not after the expiration of the 1 year after the return is filed, but not after the expiration of the period prescribed for the assessment of tax, okay, upon payment of the amount of the estate tax, okay? So, pwede siya magpa-discharge na from personal liability. Okay, balik ta. The executor or the administrator has the personal liability to pay for the estate tax. And then, the beneficiaries are subsidiarily liable to the, in proportion sa ilang share, no, sa estate, okay? And after payment of the estate tax, the executor or the administrator can now apply for or request, no, from the commissioner na pwede na sila i-discharge from personal liability. Okay? Okay, kindly read the rest of the provisions. Let me discuss to you the amendments of the amendments under that train law regarding estate tax. Para makarelate ko mo, no? Okay? Okay. First is, what is the new estate tax rate? Before, yung estate tax natin is naka-table, graduated, and mas higher ang iyang tax. Okay? Mas higher ang tax rate before. So, in the previous law, depende sa value sa imong estate, no? Ang rate of tax. So, ang tawagan na is progressive ang tax rate na to in the previous law. So, the higher the value, the higher the tax rate. Okay? That is the old law. But in the train law, the new law, fixed rate tayo sa train law. At the rate of 6%. Okay? 6% of the net taxable estate. Okay? Net taxable estate, meaning gross estate less allowable deductions equals net taxable estate. Then, mag-multiply tayo doon ng 6%. Okay? That is one of the amendments. The second one is the standard deduction was raised to 5 million from 1 million. Okay? 1 million noon, ngayon 5 million na. Na-discuss ko na yung reason, no? May mga allowable deductions kasi na tinanggal sa old law, gisulod na siya sa standard deduction. Another amendment is yung family home, yung allowable deduction for family home, dati 1 million lang yan. Ngayon, 10 million na. Okay, that is one of the amendments. And the law retained deductions for claims against the estate, andyan pa rin. Against insolvent persons, nandyan pa rin. Unpaid mortgages, andyan pa rin. Applicable vanishing deduction, meron. Transfer for public use, meron. Yung amounts received under Republic Act 4917, andyan pa rin. Tsaka yung surviving spouse. Na-retain din yung tax credit for foreign taxes. Okay? But with respect to non-resident aliens, hindi naging 5 million yung kanilang allowable deduction. Okay? 500,000 lang for standard deduction. Okay? And what are the new administrative requirements under the train law? Okay, ganito. In the old law, kailangan may notice of death. Okay? Pagkamatay sa decedent, within 2 months, gikan sa pagkamatay, you are required to notify the BIR. Mo nang mapansin kita mo ng dyaryo nga na ay notice of death. Kanang mga dyaryo ba, nga namin makita dito nga, si so and so namatay, inani yung mga properties, kana required na siya sa una. I-announce nimo to the public. But now, with the train law, hindi na yan required. Wala nang notice of death. The second administrative amendment is, lapit ito mo man, pasasan ako. Yung CPA certification, before, ang threshold niyan is 2 million. Ngayon, 5 million na. Okay? Para alam niyo ba yung amendments, di ba? Para pang-how kayo mo, di ba? Nganong kailangan niyo makabalo? Kay ngano na may namatay before the effectivity of the train law. Okay? Remember that. That the law applicable to the case is the law at the time of death. Oh, ayan. So, kung namatay siya before the effectivity of the train law, then the old law will apply. So, you should know these old principles. At isa sa mga magandang nangyari sa train law, is yung period of filing. Dati 6 months lang yan from the time of death. Ngayon, 1 year na. It was doubled by the train law. And another amendment is, ina-allow na ngayon yung installment payment ng estate tax. Dati wala yan. And ito, pinakamaganda. before you cannot withdraw the bank account of the decedent hanggang sa hindi mo mabayaran yung estate tax. Pero ngayon, you can withdraw na for as long as mag-withhold yung bank ng 6% sa value ng bank deposit. Yun yung friend ko, isang friend ko, namatay yung papa niya. Gusto nila i-withdraw yung bank account kasi wala naman silang pambayad ng estate, no? So, paon nila tong bank account kay para mo to ilang ibayad. Pero di man sila i-allow sa bangko kay i-freeze man na. Mag-freeze man ang mga bangka na pag namatay ang decedent, ang bank account holder. So, karon dili nila ma-withdraw. So, unsaon nila pagbayad karon? So, nakita na siya sa bag-o nga law. Okay? Na-remedy na siya sa bag-o nga law. Allowed na ka mag-withdraw provided mag-withhold of 6% final withholding tax. Okay? So, meaning to say, pag final withholding tax siya, you are no longer required to declare the value of the bank account. Nagets niyo kay final man, dili man siya creditable. Okay? Mubaya na ang prinsipyo sa final withholding, ha? So, pasabot diyan na mga bank account di ay pwede na din na siya dili i-declare sa estate tax, no? Tax return kay final withholding man sila. Ang nabayaran nimo nga 6% dito dili ka allowed na i-credit sa imong estate tax return. Kay dili man siya creditable. Final man siya, okay? Okay, that ends no my estate tax topic. We will end this this session and we will proceed to the donor's tax. We still have time left, okay? Okay, let's have a break. Bye-bye.